Super, great. And thanks very much, and thanks to Cambridge Network for inviting me along today to this webinar. I am in the Stone King offices. This is not my home, but we were just commenting about how exciting it is to have a look at everybody's houses when we're on Zoom, which is always a nice thing. And this is not my house. I'm in the office. I'm on my own, and I am social distancing, but it does mean that my dogs and my teenagers are not going to be interrupting me. So I'm very thankful for the escape. Thank you. So today we're going to have a talk about an introduction to immigration issues for businesses. I know there are some clients who are there on the line, so welcome to those of you. And you will be familiar with some of the content, but I hope that I'll be able to cover everything that will give you a strong background, a strong foundation for immigration issues to consider. And then we'll also have a little look at the impact of COVID, because of course COVID is impacting immigration as well as everything else. Bear with me, I've not actually given a webinar on Zoom before. I have mostly used different webinar software, so hopefully this will run nice and smoothly. I do like to get questions as we go along, so please do shoot questions at me and I will keep a close eye. Thank you to all of you saying good morning, and Sarah, Sam, good to see you. So, the structure of today's training, I thought we would have a look at Brexit and its impact on European nationals. We would then have a look at the future immigration system, and then thereafter move on to filling shortages in workforce, and then just a quick slide on COVID. I do have a tendency to talk, so please do interrupt me with questions, and I will keep a close eye on time and try not to go over the 30 minutes. So we'll have a look at Brexit, and actually I've just had a really interesting conversation with a client just before I came online today about what they're doing. They have 1,700 employees, and they are not asking for any information from their European nationals, and that is actually against the advice that I and all immigration lawyers have been giving. So, as you are aware, in the current climate, the European rules of free movement still apply. So European nationals are able to come into the UK, go out of the UK. They're able to come in and work and study. They're able to do all of the things that they've been able to do ever since the UK joined the European Union. And those rules still apply. So if everybody can see the screen, I've popped down the regulations, but the important point to note there is that a qualified person is a European national who's come into the UK, or indeed a UK national who's gone to a European country in order to work, to be a job seeker, be self-employed, self-sufficient, for example, a retired person. If you wonder, how do all of the British nationals move to Spain? That's because they're retired nationals and therefore self-sufficient, or students. So European nationals can move freely. And importantly, family members of European nationals can also move freely. So what that means is that you can have a Brazilian national married to a Portuguese national, and that Brazilian national need not have any visa to come into the UK because they're married to a Portuguese national. And if that Portuguese national is coming with them, then it means that they're entitled to be in the UK. So what you would have done as an employer in that situation is you would have obtained evidence of the spouses of Portuguese nationals' status and then the Brazilian nationals' relationship with them. And that would have been sufficient. But all of that is soon going to change. So post-Brexit, before the 30th of June 2021, all European nationals must hold one of two statuses. So remember, European nationals right now need only to have their European passport. Just having European passport or their ID card is sufficient, and they don't need to do anything else. But the rules have changed, and we're currently in the transition period. And during that transition period, European nationals need to apply for either settled status or pre-settled status. So settled status is for European nationals who've lived in the UK for more than 5 years. And pre-settled status is for European nationals who've lived here for a shorter period of time. And that's really important because it's a change of mindset, not only for European nationals, but also for employers, because previously we were able to accept, oh, somebody's a British national, that's okay. Somebody's a European national, that's okay, they can work for us. But actually there's another stage now involved, and that's confirmation of status. So in order for European nationals to obtain confirmation of their status, they need to prove their identity, they need to prove they live in the UK, and then they need to disclose that they've not done anything naughty. And that means no serious criminal convictions. So the application process is through the Home Office site. Now you take your mobile phone, you get your passport, and it's read. So on your passport, you should have a little chip picture, and that's what nearly everybody with passports now has. And the phone is able to read the chip in the passport. So it's actually a really clever app and a clever software that the Home Office are using. So you take your phone, it reads the software information, the chip information in the passport, and then that's uploaded, and then information needs to be put through the website. And then the government does some internal checks. So they'll check with HMRC that tax has been paid, and then they'll ask you to submit answers to the questions. So I don't know if anybody was familiar with the permanent residence application, which existed prior to this, but it was about 52 pages long. It was a paper application, and it took a long time to fill it in. So this is a very, very different process. But of course, it's IT, and IT does have its limitations. If there are lots and lots of people applying, then it can crash. And if you don't fit the standard answers, then again, it can be problematic. So if I give you the example of maybe an Italian national who came to the UK with her husband, and the Italian national then had 2 children who were British nationals born in the UK, but the Italian national has never worked because she's been looking after the children, and then she separated from her husband. She may have been in the UK for 5 years, but this is going to be more difficult for her because she won't have evidence of any tax being paid. She won't have been working. So the question is, how is she able then to evidence that she's got settled status in the UK? And it's those types of slightly different applications that can be more problematic for individuals. For example, where somebody may be volunteering, or again, where somebody may have had maybe a non-European national, but a family member of a European national, the system may have difficulties. So for some individuals, it's not quite as simple as you would expect. No questions coming up yet. Please do type them if you've got any. So as employers, what support can you offer? So for individuals who are going through this process, it's really important to remember that it is something for an individual to apply for. It isn't something that the employer needs to do. The employee needs to go ahead and make the application themselves. But a lot of individuals are either confused, some of them frustrated because they don't feel that they should be doing this. Particularly in Cambridge, we have a lot of European nationals who've lived here for a very long time. And there is a sense that this is a process they shouldn't have to go through. But unfortunately, it is something that needs to be done. All individuals, all European nationals need to make this application. And we as employers can encourage our European employees to take those steps. So what can we do? The first piece of advice that I offer is write a letter to European nationals. If you have quite a few European employees, it is a good idea to either meet with them or to give them a letter to explain the situation, to explain the deadline of June 2021, and to explain that they will need to get that evidence so that you are able to have that evidence on file for your right to work checks. You can use the employer toolkit, which is on the government website, which is also very useful. And you can also write letters of support. So, for example, the Italian lady that I just explained, if she hasn't been working, but she's perhaps been volunteering for your organisation, you might want to write a letter of support to say how long she's been doing that for. And that would, of course, help that individual in being able to evidence how long they've been here. So what about European nationals who haven't been in the UK for that long? We may have European nationals who are joining our organisation now, and it's really important to bear in mind those dates. And I do have some individuals who are coming to see me at the moment, and this is really crucial because they need to understand how important it is to register, because if they don't register, they may well miss the opportunity under this scheme if there's no evidence of their residence in the UK. So between the 31st of January 2020 and the 31st of December 2020, that's the transition period. So that's the period that the Home Office are expecting people to apply for settled or pre-settled status. After the 31st of December 2020 until the 30th of June 2021, that is when European nationals must make the application, because the deadline is the 30th of June 2021. Now, what that means for employers is that any European nationals that are working for us post July 2021 must have pre-settled or settled status. And we must have that in our right to work checks. So I hope everybody here is familiar with right to work checks, but the law says that if you are employing anybody age 16 or over, and they are subject to immigration control, you must have a statutory excuse. So a statutory excuse is a reason to justify the lawful employment of an individual. And so long as you have a statutory excuse to show that that you have correctly checked that that person has a right to lawful employment, you will not be subjected to any kind of penalty. Now, a lot of people say, but a right to work check is required by law. No, not quite. It's by law, you need to have a statutory excuse. And in order to get a statutory excuse, the mechanism to do so is by conducting a right to work check. So a right to work check must be conducted for everybody, irrespective of where they're from, irrespective of nationality or anything else. You have to do it whether somebody's British, European, or non-European, non-British national. You need to obtain the person's original documents. You then need to check the validity of those documents in the presence of them. And then you need to make and retain a clear copy. And importantly, and one thing that lots of people miss, you need to make a record of the date the check was taken. So I always suggest on your HR files, whether that's electronic or whether that's a paper format, that you check the document in front of somebody, you then copy it, you then write your name on the document and the date you've checked it and sign it. And then you can either scan that and put it on or put that information in, but that document needs to be retained. And you should do that for every individual working for you.
I've got a question here, Julie, from Lisa Roberts. Does the same apply for temp interns?
So a statutory excuse is required for anybody within your employment. So if it's an intern and you are employing them, no matter whether it's temporary or not, then yes, it will apply. Does that answer your question, Lisa?
Mm-hmm.
If you want to ask another one on that, Lisa, just drop another question. So if you do not obtain a statutory excuse for individuals working for you, you could potentially be liable to a penalty. So the civil penalty is up to £20,000 for each illegal worker. And the criminal penalty is potential fine or being put in prison. Now, I don't imagine anybody sitting here on this webinar will be liable to anything like that. We often read about takeaways who are illegally employing people. There are particular types of businesses that are more that are subjected more to the types of criminal penalties. But a civil offence is often used by the Home Office to teach businesses a lesson. So it is really important that we're on top of this. Now, I've got a couple of questions coming in. For the temp interns, do they need to be settled or pre-settled after June 21? Yes, anybody within your employment, if they are European nationals, needs to have settlement status or pre-settled status. It doesn't matter what type of employment they've got, whether they're temporary or not, they need to have that status to be in the UK. And a question from Anne, do you know about an individual who has applied for asylum in the last 12 months? Anne, what do you mean? If somebody has applied for asylum, then you will have to conduct the right to work checks. And what they will give you is evidence of their application. And so that's quite difficult. It might be that they've instructed a solicitor and that the solicitor has submitted an application through recorded or special delivery, and they give you the special delivery or recorded delivery number. Now that's quite tricky to use as a right to work check. What you need to do is go through the right to work checklist, which is on the Home Office website, and you would need to use the employer's checking service. And you go onto that and you would put all of the information in. The applicant or the employee would also put the information in, and you will then get a statutory excuse from the government. So if that individual has an outstanding asylum claim, then you will get that confirmation of a statutory excuse. However, Anne, most asylum seekers do not have the right to work. So I would question whether they are entitled to work. The only situation, and I've been doing this job for a very long time, the only situation I've ever had where an asylum seeker has had the right to work is where they've been in the UK with a lawful visa for a long time, and then they claimed asylum. This was a Zimbabwean national. They claimed asylum because they couldn't return to their country of origin. And then we asked for special permission under the immigration rules for that individual to work on the basis that she was supporting her child and already had a job. Now, it took a long time for us to get that permission. So I would question, Anne, whether they do have a right to work, even if they've got an outstanding asylum application. Hope that answers your question. Alexi, do you need to check consultants' right to work? Right, well, that's an interesting question. As a consultant, I'm going to presume that they are not in your employment, that they are not employees. If they're not employees, then a statutory excuse won't really help you. However, and Alexi, I'm not sure what organisation you're from. You've got to think about the reputational damage to your organisation. So if we imagine that we have a consultant working for us and they are unlawfully in the UK, they should not be in the UK because they don't have a visa to be here. If you are using them as a consultant, there is a massive risk that that could then detrimentally impact the reputation of your organisation. So I would think very carefully. The statutory excuse would not assist you in terms of defending you against any kind of penalty, because you're not going to get a penalty because they're not an employee. However, if you are an organisation that is large and it would have a serious impact on your reputation, then I would think about conducting the right to work checks just for that reason. So, Alexia, I hope that answers your question. Michael, question from you. Does this apply for long-term self-employed cleaners who work a few hours per week? Again, they're self-employed. If they're self-employed, then a statutory excuse will not assist you. If, however, well, firstly, you need to be 100% certain that they are self-employed and that there is no possibility that it could be suggested they're actually employees within your organisation. That's the first point, because we do know that that can sometimes happen. The second point is, what type of organisation are you? And could this potentially have an impact upon the reputation of your organisation? So remember, right to work checks, they can have a number of, we conduct them because we want a statutory excuse because we don't want to get fined. That's why we do it. If they're not employed, then you're not going to get a fine. But if somebody is working within your organisation and they're not legally in the UK, could potentially have quite a significant impact if it was to come out in the press or anything else. Michael, I hope that answers that question. So, right to work checks and EU nationals. So we talked about the settlement scheme. We talked about settled or pre-settled status. Now, important to note that when you do apply under the settlement scheme, you don't actually get a document. It's not something you can copy and then pop onto the file. And so it is an electronic document, like the employer checking service for right to work checks. It's a similar type of thing. So the employee makes the application, they'll then get a PIN number. They pass that to the employer, and the employer then logs on, and then a picture of the individual comes up and it will say, this person has settled status in the UK. I personally then print that off and I pop it onto the file, but you can screenshot it. So long as it's compliant with right to work checks, you can do anything you want with it, so long as you've kept evidence of it. So a quick look through sponsorship. At the moment, we work on the basis of tiers. Tier 1 being for business investors and entrepreneurs. Tier 2 which is general sponsored workers or ministers of religion. Tier 4, students, and Tier 5, temporary workers. So we have 4 tiers. There's no Tier 3. Tier 3 was intended for low-skilled workers, and we do not have the opportunity to sponsor low-skilled workers. And newsflash, the Home Office have no plan to allow us to sponsor low-skilled workers. So Michael, bad news for you if you wanted to employ any low-skilled cleaners from the European Union, unfortunately won't be possible. So at the moment, we're calling them tiers. Now, the Home Office are introducing the new points-based system, and the new points-based system is not going to be based on tiers, but everything else is pretty much the same. So in order to sponsor individuals, and having a quick look through the attendees today, I can see that some of you have got sponsorship licenses. You have to make an application, you pay the fee, provide proof that you're a bona fide organisation and that you're eligible and suitable to sponsor individuals. You then have some key personnel, and they're the individuals who are working within the sponsor management system. And that's the gateway that we use in order to sponsor individuals coming to the UK. And so we have an authorising officer. So that's the person with the ultimate responsibility for hiring and firing. We have the key contact, which is the person who liaises with the Home Office, often your legal representative. And then we have the level 1 user, who's the person who conducts the day-to-day administration on the licence. So sponsorship to fill shortages. Key points to remember, and these are the key words really. SOC code, which is your standard occupation classification. That's going to be crucial in the new immigration system that's coming in. We then have salaries. We have the resident labour market test. I am happy to say that the resident labour market test will soon be gone and won't be introduced in the new system. The shortage occupation list and the sponsor management system, which I've just explained, is the gateway to which we then conduct all of our certificates of sponsorship and everything else to get people in. The other types of visas that you might be familiar with are visitors visas, Tier 4 visas, youth mobility scheme, and family visas. So the youth mobility scheme, I do think there's quite a few individuals who rely on this, particularly in the Cambridge area, Australian nationals, Canadian nationals, who come to the UK, they get a maximum of 2 years, and so long as they're under the age of 30, they get that visa. It's not a sponsored visa, but they can come and work. So a lot of our schools in this area do have teachers who are reliant on the Tier 5 visa. Often the difficulty is then that those individuals settle in the UK, they quite like it here, and then they want to stay. So we then have to find a way for them to transfer onto a different visa. Visitors visas used to have different names. So we used to have the business visitors visa, we used to have a standard visitors visa. Now they're all falling within the same thing. And it is possible for individuals to come into the UK on a visitors visa and conduct certain amounts of business work. So that's an important point, and it's important when we think about movement of European nationals in the future. So the future immigration system. From the 1st of January 2021, free movement will end, and the government's point-based system will be introduced. Absolutely crucially, European nationals will be treated exactly the same as non-European nationals. So it doesn't matter if somebody is from Spain or if they're from Mexico, they will have to apply under the same system. So the policy paper, and we're getting more information all the time, so more information was released this week. The points-based system, the salary threshold has been reduced. So it's reduced from 30,000 to 25,600. What that means is that anybody wanting to come into the UK will need to earn over that amount, unless they're in a shortage occupation. If they're in a shortage occupation, then they will be able to come in so long as they meet other criteria. An employer will need to have a sponsorship license, and they will need to be able to sponsor individuals to come in. So if, for example, you are a care home in Cambridgeshire and you employ quite a lot of Spanish and Portuguese nurses and carers, the difficulty is going to be whether your carers reach the threshold and with the nursing positions that they fall within the shortage occupation. So the shortage occupation list is issued by the Migratory Advisory Committee, or it's recommended by the Migratory Advisory Committee, known as the MAC, and then the Home Office adopt it. And all nursing positions are currently on it. as are some teaching positions. Now, looking at the skills threshold has been reduced. It will be anything above A level. So everybody who wants to come in will need to be above that level. And crucially important, that will be the same for non-EEA as well as EEA. So Anne, we've got another question from you. Is it worth Irish nationals applying for settled status just to have some legacy paperwork in addition to an Irish passport? Great question, Anne. No, not necessary. And it's not necessary because there is a common agreement between Ireland and the UK that exists. It's existed for a long time, but with the European Union as it was, Irish nationals relied upon their right of free movement. But any Irish national in the UK is entitled to stay, remain and settle, and they don't need to have any further evidence of that. Gurpreet, thank you. A question from you. When a person is in the UK on a Tier 5 youth mobility visa, and their employer wishes to continue their employment under Tier 2, good question. Currently, my understanding is that you cannot apply within the UK. Are there exceptional circumstances leaving COVID-19 aside? Okay, Gurpreet, great question. So I'm going to explain the question. If somebody is here on a youth mobility visa, let's give the example of somebody working in a school. My daughter had an amazing Canadian English teacher at her local school. She was such a wonderful lady. She was there for 2 years and her youth mobility visa was coming up to an end. Unfortunately, as an immigration lawyer, I always know everything about people's immigration status. It's always my first question. But there we go. So her visa was coming up to an end and she wanted to stay, but she would have needed to get a certificate of sponsorship. And the school actually didn't have a sponsorship license, so she ended up returning to Canada. The answer, Gurpreet, is no. You have to leave the UK. Now, this is called switching. So to switch from one visa to another visa, to move from one visa to another visa is called switching. And you have to have permission to switch. There are only certain ways that you can switch between visas. So if you're in the UK and you've completed or have undertaken a large proportion of a PhD or a master's course on a Tier 4 visa, you are able to then switch onto a Tier 2 visa. But to go from a Tier 5 youth mobility visa to a Tier 2, you can't switch. So it means that you've then got to go back to your country of origin or a country that you have habitual residence in, apply for the visa and then come back. A pain. But that's with putting COVID aside. Not putting COVID aside, at the moment you are able to do it because of COVID. Another question from Anne. I'm thinking of Windrush, not have a piece of paper or digital, but Anne's leaving, so I think we've missed her. Her question was about Irish nationals and Windrush. Yeah, Irish nationals do not need to have any kind of documentation. I absolutely understand the concern. Windrush, of course, was a huge scandal and highlighted a number of issues that immigration lawyers have been harping on about for a long time. I've acted for a number of Windrush generation applicants, but Irish nationals do not fall within that, so please don't have that concern. Okay, so the future immigration system, the key questions that your organisation needs to address are, do you rely on workers outside of the UK? Is your organisation thinking of expanding? And do you work in a sector where there could be a shortage of workers? If your answer to any of those questions is yes, you must think about a sponsorship licence. Now, the information published by the Home Office this week was that if you are thinking about getting a sponsorship licence because of Brexit, you should do so as soon as you are able to. And I thought that was very strong wording from the Home Office, actually. But it's a message to every employer that there is going to be a massive demand on sponsorship licenses. And it is something that you need to really proceed with and take seriously now before the demand on the system gets too great. We know what happens with the immigration system in the Home Office. Where demand is great, the systems can't cope. So the sooner you make that application, usually a sponsor license application can take about 8 weeks. Now, I submitted an application 11 weeks ago for a very large independent school that had a change of ownership, and that is still outstanding. Now, obviously, we're in exceptional times right now, but we need to be aware that there can be reasons for delay. There are often visits undertaken by the Home Office. So you need to be prepared for that. It does take a long time to get the application prepared. You do need a large number of documents. So I would suggest that if the answer to any one of those questions, and they're important questions that you need to take back to your chief exec or managing partner, then you should think about sponsorship. Now, for existing sponsors, if you have a license already, have a think about whether you need to increase your COS allocation. Lots of organisations right now are having to renew their annual allocation because it's a certificate of sponsorship. If that's you, have a think about putting extra ones on. And the last slide that I've got for you is about COVID-19. And as I said, immigration, of course, is affected, and especially if you have a sponsorship license. And it's really important that you bear this in mind, because if you do have a sponsorship license, you may not be compliant right now. And we need to work out, is that okay or is it not? So reporting duties have been relaxed. Currently, there's no requirement to report coronavirus-related absences or a change in work address. So if you have a sponsorship license and all of your staff are working from home, don't worry, you don't need to report it. You normally would have to, but you don't need to right now. And there's no requirement to cease sponsorship after 4 weeks of unpaid leave. So again, that's important to bear in mind. But all other reporting and recording keeping duties remain the same. So one of my organisations relies on, it's an IT organisation, startup, relies heavily on foreign nationals. They've got a sponsorship licence. Quite a few of them have gone back to their country of origin. That, of course, means that their residence address has changed. That would be something you need to report. Okay. And then additional concerns are right to work checks. Are they up to date? Delay in start date. Remember, that's something that you do need to report through the sponsorship license. And lastly, furlough. Because if you have staff that are furloughed, you would need to report that. And if some of your staff that are furloughed are actually key personnel on your sponsorship license, again, that means that you're non-compliant. So you could lose your license over that. So be very wary of that. If your level 1 user is your secretary and he or she has been furloughed, then you will need to change it to somebody else, even if it's you, and just have the same person on the sponsorship license, but you will need to take those steps. One final question from Sam. Will the slides be emailed out to attendees? And I believe they will be. I will send the ones that can be sent out to Louise at Cambridge Network, and she'll forward them.
Thank you very much. We are recording this as well, so we'll be putting that on our YouTube channel.
Super.
As long as we haven't said anything contentious.
So, any more questions before I sign off? Is everybody happy with all of that? My details are there should you want to drop me an email. Catherine, I'm glad you found it useful.
One more question I can see from Sam.
Okay. What advice would you give about timing for restricted certificate and employing someone? That's a good question. In light of COVID, yeah. It's a tricky time actually, Sam, because so we applied for a number of different clients. We applied for restricted certificates of sponsorship. So for those of you who aren't familiar, there are 2 types of certificates of sponsorship. I did 2, which makes 4, 2 types. Restricted certificates of sponsorship are used for individuals outside of the UK. Unrestricted are for individuals in the UK. So for anybody who you're applying from outside the UK, what you have to do is you need to make an application by the 5th of the month. And the Home Office then make a decision on the first working day after the 10th of the month. And then you get it, and it's valid for 3 months. So if you think about those timelines, we did that in February time for some individuals, and then suddenly they weren't able to come to the UK because there were no flights. And we've been trying to either amend their restricted certificates of sponsorship, alternatively contacting the Home Office. So I've been liaising with the Home Office a lot over these types of individuals. So Sam, I see that you've identified somebody in Turkey. You've done the resident labour market test, excellent. And you've got the licence, well done. So I would make the application for the restricted certificate of sponsorship because today is the 15th. That would go in by the 5th of May. You would get a decision on the first working day after the 10th of May. And if you do that, you've then got June, July, August. So you've got until the 10th of August. If your start date is anytime from the beginning of September, then the timeline would probably work. And listen, I've no crystal ball, but I would hope that there's movement between Turkey and the UK by August. So I would anticipate that that would be useful to make the application now. And I do think if there wasn't movement between the UK then and Turkey, that the Home Office will issue some kind of leniency around your certificate of sponsorship. But what I would say, Sam, is you need to keep an eye on the date on the resident labour market test, because for anybody who isn't familiar, it's only valid for 6 months from the date it was started. And it's a pain in the bottom to do a resident labour market test. There's a huge amount of red tape, and you have to advertise in correct places for a certain number of days, and you need to take photographs and screenshots. So it's quite difficult to do it. Well done for doing it. Sam agrees, it's a pain. And so I would suggest that you get the application in for a restricted certificate of sponsorship. Another reason to do that is it's unlikely to hit the monthly limit next month because many people won't be doing it. So even more of a reason to do it. So if I were you, I would crack on, do it. And then if you can't get that individual over, liaise with the Home Office. Hope that answers that question. Michael, I'm glad you found it useful. Any other questions before we switch off? I don't think so, but my details are there, and I would suggest that everybody contact me on LinkedIn and just connect with me. I do put lots and lots of information up on there, and also the webinars that I'm conducting are also going up on there.
Fantastic. We'll add on loads of Stone King webinars and as soon as you've got them onto our site as well and push them out. So yeah, brilliant. Thank you very, very much for speaking for us so eloquently and answering the questions as well. I know it's not easy to keep an eye on 2 things at once sometimes, so fantastic. Thank you everybody for joining us. It's been a pleasure.
Super. Thanks everyone. Take good care. Stay well.
Thank you.